Directors of company are appointed. Directors oversee company's affairs and governance effectively. Companies Act governs their roles and responsibilities. Appointment ensures efficient management and operational control, key for decision making and business strategy alignment. Promoters often appoint initial directors upon incorporation. Shareholders have authority to appoint certain directors. Law mandates qualifications and restrictions for directors. Types include executive, non executive, independent directors. Directors serve fiduciary duty towards companies' stakeholders. Effective appointment ensures business continuity and compliance. Types of directors appointments: appointment by promoters. Promoters appoint initial directors during incorporation. AOA often prescribe appointment process. Incorporators of startups appoint founders. Promoters. Nominees typically hold significant company stakes. Appointed under Section 152 of Companies Act 2013. They ensure early stage operational stability and focus. Shareholders' agreement may restrict promoters' appointment rights. Example: Ramesh Kothari versus XYZ Private Limited. Court upheld validity of promoters' appointment mechanism. Promoters ensure strategic alignment and vision execution. Appointment by shareholders: shareholders vote during general meetings for appointments. Ordinary resolution often suffice. Special resolutions may apply in specific appointments. Majority votes determine selection. Example: appointment process detailed in Tata Sons bylaws. Shareholders' democracy ensures transparency. Voting rights governed under Companies Act. Proxy voting facilitates absentee shareholders' participation. Shareholders' approval aligns appointments with majority interests. Balanced appointments prevent power concentration and conflicts. Appointment by Board of Directors. Board appoints directors to fill casual vacancies. Casual vacancies occur due to resignation or demise. Appointment ratified during next general meeting. Example: Board appointed CFO as interim director. Section 161 governs casual vacancy appointments. Procedures: Board ensures operational continuity amidst unforeseen situations. Vacancies prevent functional disruptions within corporate governance. Courts often assess legality of board appointments. Example: XYZ Limited versus Ramnath. Valid board appointments upheld. Efficient board mechanisms maintain managerial consistency. Additional appointment types: government nominated directors. Government nominated directors in public sector enterprises ensures alignment with national interests and policies. Appointments made under statutory provisions and guidelines. Example: PSU directors nominated by Ministry of Finance. Section 1613 governs appointment in certain situations, ensures checks and balances in government enterprises. Accountability to Parliament or state legislature mandatory. Case involving Coal India Limited board appointments. Nominations based on expertise in relevant sectors, balances public sector goals with corporate governance standards. Independent directors appointed to ensure unbiased decision making and governance, governed by Section 149 of Companies Act 2013. Independent prevents conflicts of interest in management. Mandatory for listed companies and large unlisted companies, selected based on expertise, not direct business relations. Example: appointment criteria defined under SEBI LODR regulations. Court emphasizes independence and neutrality of appointments. Case: XYZ Limited versus SEBI upheld appointment criteria validity, protects minority shareholders' interest in corporate boards, ensures compliance with best governance practice internationally, alternate directors alternate directors appointed for directors prolonged absence governed by section 161(2). Articles of association must authorize such appointments. Temporary appointments during foreign assignments or illness. Director A appoints Director B as alternate. Shareholder approval validates alternate directors' nominations. Limited authority must align with original director's intent. Example: Tata Sons alternate director case during litigation. Legal disputes often clarify role limitations and durations. Alternate appointments safeguard companies' operational continuity. Nominee directors appointed by stakeholders like lenders or investors protect stakeholder interests in decision making processes. Example: bank appoints nominee director for loan security governed under agreements between company and nominating party. Section 161(3) allows nomination for contractual agreements, often possesses financial expertise for oversight roles. Case nominee director disputes resolved under arbitration clauses, ensures compliance with lending or investment terms, balances interests of company and external stakeholders, prevents potential mismanagement in high risk financial situations. Executive directors actively involved in daily operations. Appointment reflect managerial or technical expertise roles. CEO appointed as executive board director. Shareholder approval requires during general meetings governed by employment contracts. Detailed specific responsibilities. Courts recognized executive directors fiduciary responsibility strictly. Appointments often tied to performance metrics and outcomes. Case legal clarifications on executive directors' liability exposure, key for operational leadership and strategic execution alignment. Enhance accountability for day to day organizational decisions. Relevant case laws: Ramnath versus XYZ Limited, director appointed contested due to procedural deviations. Court emphasized strict adherence to legal guidelines. Rules upheld AOA provisions. Appointment process validated under Section 152 provisions. Procedural fairness highlighted for future appointment practices. Shareholder approval deemed critical for board appointments. Judgment strengthens transparency in corporate governance, clarifies board authority in casual vacancies. Appointment legitimacy enhances confidence among shareholders. Legal precedents guide appointments in similar cases. Conclusion: director appointments ensure leadership for organizational success. Balanced processes enhance transparency and shareholder trust. Laws governing appointments safeguard stakeholders' interests effectively. Strategic appointments align with corporate governance standards. Appointment processes must follow legal and procedural frameworks. Judicial interpretations provide clarity on appointment practices. Shareholders, promoters, and board uphold appointment integrity. Regulatory oversights prevents malpractices in director appointments. Effective appointments ensure robust management and compliance. Leadership continuity critical for sustainable business operations.